Hello and welcome to Quadcast, Quadrant Chambers weekly discussion forum. We are four barristers from London. That is me, Paul Downs, Poonam Milwani, Claudia Wilmot-Smith, and you with us this week. From behind the scenes, she emerges, looking slightly light deprived and the like. Emily Saunderson, our producer, is filling in for Joe Sullivan this week. Hi, Emily.
Hello.
So we're going to do catch up, and I think, Emily, as you are, it's your inaugural programme, we should go to you first. What's your...
She's not filling in. Joe could have done this, but it was just jolly well timed that Emily came onto the programme. Plus, we wanted to outnumber you, Paul, with 3 women to 1. So thank you, Emily.
I'm going to talk a lot about conspiracy today. So, 3 against 1 seemed like a good way of illustrating how people might conspire.
Gang up
How appropriate. The main case is Racing Partnership. And, I don't know what my odds are. But anyway, Emily, what's your news this week?
Right. So my news is that it was my birthday on Sunday. My brother very kindly baked me this enormous chocolate cake, and I've got a picture of it. I really like chocolate cake. So it was a real treat to get this massive chocolate cake on my birthday. And usually I'm fighting for the cake. It's a real struggle to actually hold on to some cake after my birthday. But this year, because of lockdown, we have been soldiering through this cake together. And it's Thursday now, and we reckon we've got another 3 days worth of cake. So the supplemental news is I've probably had enough chocolate cake for the next few months now. But yeah.
But Emily, you're in Chambers, I can see.
I am.
Come in, and there are a couple of people who are having to do trials from Chambers. So
I couldn't possibly bring the cake in for them. No, it would get damaged on the way in. It would be terrible. Anyway, Claudia, what was your news?
Well, I thought I'd carry on in my elephant-related news. So last week, I told you about Happy the elephant. I watched the oral submissions. I had the delight of seeing someone appear in New York Superior Court saying, I appear on behalf of Happy the elephant. We don't yet know whether Happy is a person, but Islamabad Zoo had to release an elephant from unlawful imprisonment. Effectively, its rights were being infringed. And Coven the elephant had his farewell party this week, where he was sent off from Islamabad Zoo to an elephant sanctuary in Cambodia because his rights were being infringed in the zoo. He even had people singing to him as he left. That really sweet. Look, he's being serenaded because he got released from captivity. The Islamabad High Court released this elephant after a 4-year-long campaign by Cher saying his rights were being infringed. I don't have any news because of lockdown, so I've been following elephant news stories.
That's good news, though. That's good news.
So my news, well, it's probably not breaking news. You've probably all known it for ages, is that I am officially a total idiot. Because here we are in lockdown with 4 of us working from home at the moment, 2 more coming soon. And I put the entire house under scaffolding because the outside needed to be done. So I have blocked 90% of whatever light there is in London in the winter. We have to listen through all these different windows to the sound of all these workers chatting, swearing, and their radios blaring. But even worse, they're doing the outside frames at the moment. And so that the paint doesn't stick, they need all the windows to be as wide open as possible while the paint dries. So it's about -6 degrees in every room in this house. And we are freezing and everyone's really, really angry with me. Paul, have you got better news than mine?
Well, I've got no great news because I'm preparing for a trial with, I've got a very difficult junior, I have to say, who's causing me all sorts of angst.
Is that the one we've sent to captivity behind the scenes?
Unbelievable. You wouldn't...
Or the one who's been released.
Unbelievable. But I won't go there. No, I've got a quiz question because the quiz went down very well last week. So I thought we'd repeat it this week. So I've got a picture. I'm going to put it up. Don't anybody say anything. There is a picture of an individual. Now, that is a fairly well-known person, and they have a link, as we zoom out from the picture, they have a link to one of the cases that will be mentioned, and you have to tell us or tell me via the email, that's quadcast@quadrantchambers.com, what that link is. Not just the...
I've already worked it out. This one's so easy. I know the answer.
Only because I discussed it in rehearsal. So That's the only reason the team know, but they wouldn't know otherwise.
I only know because
Claudia doesn't know.
No. So anyway, that person has a link to one of the cases. You can't. It's not just naming the case. If you just name the case, that would be easy. You just guess. You've got to say what the link is, and the first person to answer by email will get a bottle of champagne from me personally. We sent out last week's winner's champagne. He was very
happy birthday. It's Emily's birthday today. I've been asked to drop her off a drink, which I'm delivering.
Goodness me.
Much to her shock when I came in the door. But there we go. Happy birthday. You've got a lot of topping up to do, and I hope that you really enjoy it. Have a good time.
Back to the quiz in a minute. Emily, what drink have you got?
Old-fashioned whiskey Buffalo Trace.
Can you not make such an ugly face of disdain?
Right, thank you. That's lovely. Thank you very much.
Cheers.
Delighted.
Right, it's got orange.
Enjoy old-fashioned.
What do you think I was, Emily? What do you think I came into Chambers for today?
Oh,
I was cutting that orange peel for you.
Oh, you're so
Delivering the glass. How sweet is that?
But keep that glass safe. It's one of mine. Keep it safe.
It's lovely. I will.
Yes.
Emily.
Happy birthday,
Thank you,
darling.
Emily.
Happy birthday. Right. Back to the quiz. So if we can put the picture up again, that person has a link to one of the cases we're going to mention. You have to email Quadcast at quadrantchambers.com and tell us what the link is, not the case. You have to tell us what the link is. Well, and the case, I suppose. And the first person to do that will get a bottle of champagne. Right, look, we're looking at economic torts this week and this recent case of Racing Partnership. I have to say, we have had more difficulty interpreting this case than I think any other case that we have dealt with on Quadcast since the programme began. We've read it and reread it, we've debated it, and we all think it's pretty difficult to work out exactly what it holds and what it doesn't. But before we get there, Claudia, economic torts, the back end of Clark and Ninsell, the place that few people dare to tread. Well, I mean, what are they all about? Where do they come from?
They all come out of labour law, really. So trade unions used to be illegal in this country. And then in the 19th century, I think it was, they stopped being illegal. But you had Lord Halsbury as Lord Chancellor, and he was just this clown reactionary who basically thought, well, if workers are allowed to unionise, what next? They could all get together and start asking to be paid real money. And that was obviously completely unacceptable. So you have these cases. The first is Allen and Flood, which is about really whether trade unions can organise strikes without fear of legal reprisals. A ship was being built in London, and there was this squabble between the shipwrights and the boilermen. So there's a lot of talk about the shipmen and the ironmen. But basically, it turned out that two of the shipwrights had previously done ironwork, and the boilermen were having none of it. So they said that if these two guys turned up for the next day, none of the boilermen would. So the person who was in charge of the project said, well, off you go then, chaps. So these two guys lost their right to work on this ship. They didn't have a contract entitling them to. They sued the boilermen. And the Lord Halsbury, clown reactionary, summoned the judges. Last time it had happened, so there were 9 House of Lords, 8 judges giving their opinion. And actually, the House of Lords said the fact that they may have tried to stop these guys from working didn't mean that they couldn't lawfully threaten to withhold their labour. So intention isn't relevant. But Lord Halsbury got his revenge with another strike case. A butcher didn't employ union men. And the union said to one of his best customers, basically, don't go there. He doesn't employ union men. But the customer didn't. The union got done for conspiracy. Because whilst they could lawfully say to this guy, don't shop there, they were doing it to try to do down his business.
So when were these cases, Claudia?
19th century. So this is under Lord Halsbury, who was basically really against trade unions. And so he said that if a bunch of people get together and do stuff which is in itself lawful, it becomes unlawful if you're doing it to try to cause economic harm to another person. For example, if they try to cause harm to their employer.
Industrial relations and also competition, I think.
Yes, so it comes up in competition as well. But the essence really is that the people ganging together. So if Poonam, Emily and I threaten to do something which we're completely entitled to do to stop Paul getting work, because we don't want him to have work, we can be liable for conspiracy, despite the fact that we're not doing anything that would individually be wrong.
Okay,
and that's all means conspiracy.
First of all, Claudia, you shouldn't give away conversations the three girls have had earlier today. But secondly, so that people don't get confused, there is two different things, right? There's conspiring to do something by lawful means, which is what you were talking about, where the test is that you've got to predominantly intend to injure Paul on this scenario.
Exactly.
And so then there's this other one.
We want to hurt Paul, not because we want to get anything for ourselves.
But then there's also conspiracy, but where you're going to do unlawful means. And if the means are unlawful, the mens rea intention is less. You have to have an intention to harm Paul, but it doesn't have to be the predominant one, right? There's two
means to an end. So, for example, diverting Paul's work to us is enough, or there's some suggestion that constructive intention is enough. So if we know that Paul will suffer harm, then the fact that we're just doing it for our own benefit is irrelevant. And I think unlawful means conspiracy is a bit of a mess. We're going to talk about the...
Yeah, let's not get ahead of it. So there's lawful means, and today we're concentrating on unlawful means.
Out there because there's intimidation, there's, apart from conspiracy, you've got causing loss by unlawful means.
Procuring breach of contract.
There's a whole range of, but they tend to come out of unfair practices in commercial dealings.
Yeah.
A broad title.
Which is kind of a hard thing to regulate, right? When it's all about profit, which may be at the expense of someone else.
And the modern era, I always regard the modern era of these torts is being since Douglas and Hello. That was you all remember that was the great case. Michael Douglas and Catherine Zeta-Jones getting married at the Plaza Hotel in New York, sold the right to the photographs to OK magazine, and an undercover gatecrasher freelance photographer got in, took photos, sold it to Hello magazine, who then did a spoiler. And we don't really go into detail of it, but all these issues of how far can you go before you become guilty of a tort in these areas was debated at length. But we're still not really sorted, are we, Poonam? There's still some pretty big questions, and one of them we're going to talk about this week.
Yeah, well, as you said, we've struggled. This is a Court of Appeal judgment that came out in October 2020 in Racing Partnership, 65 pages long. We've all read it several times. We have argued about it. I'm still really confused. And I'd say the big issue that still remains conceptually for us, so you get there, is to what extent do the conspirators need to know that the means are unlawful? And if you don't need to know, which, spoiler alert, is what the Court of Appeal by a majority held, if you don't need to know it's unlawful, what do you need to know? I mean, what do you need to know? What kind of infection? That for me is the big issue. We're talking about these. But the other part, but Emily, tell us what the facts of this Racing Partnership case are.
Okay, so I'm going to need your help. I'm sure you pick up if I miss anything important out.
Just remember to keep sipping the whiskey while you're doing it. It will help.
Yeah.
Left it alone. I had a sip and it was like, oh my goodness, I haven't had a drink for at least 2 days. Anyway, so the Racing Partnership. The Racing Partnership, it's a case in misuse of confidential information and unlawful means conspiracy. Now, the Racing Partnership was the claimant, and it had a number of different contracts with race courses across the country, whereby it paid a lot of money to the race courses, and the race courses provided it with certain data about the racing. So it's horse racing and betting that we're interested in here. The race courses provide this information to the Racing Partnership, and the Racing Partnership then sells that information to bookmakers who don't have a physical presence at the race course. So the information allows these bookmakers to compete with bookmakers that do have a physical presence on the race course. So
what kind of information is this? I'm not a betting woman. What kind of stuff?
I'm not a betting woman either, but according to the judgment, it's there was something described as the key race day triggers. I think it's information like the start time, who the runners actually are, the definitive results. So if there's been a steward's inquiry, what's actually happened.
Basically, it's everything you need to work out odds, right? Because betting's super profitable. People on the race course can see the horses and they know what the going's like, because some horses run faster when the ground's hard and some horses run faster when the ground's soft.
Okay, just confess.
I'm getting the feeling that Claudia's got more than a passing interest.
Yeah, I think so too.
Case, which we're going to get to.
All of this information helps you work out what odds are, and if you know sort of proper odds, the people on the race course know them, the people off the race course don't, and there's this information barrier which required them to contract, right?
But hang on a minute, I need to simplify this. Okay, right. So I've been to a couple of race courses in my time, but I'm not a Claudia by any means. Okay, so you've got the information owned by the race courses.
Yep.
You've got in the middle here, you've got the Racing Partnership, the claimant.
Yes.
And then on the other side, you've got bookmakers who are away from the race course. They're not the ones that are on the race course with their, doing all this sort of stuff. They're the ones off the race course.
Yes, that's exactly right.
Data goes here to the middle and then off to the bookmakers off the race course.
Yeah, so the Racing Partnership sells the information to the bookmakers, makes money doing that, but it pays a lot of money for the exclusive rights to that information from the race courses.
How much?
So I don't think it says in the judgment what TRP was paying, but before the Racing Partnership, it was the defendant, Sports Information Services, SIS, that had this contract, and that was paying an 8-figure sum, apparently. So it's not a small amount of money.
It's more than 10 million.
Huge amounts of money.
Okay.
Okay, so then what happened now?
So what went wrong?
So what went wrong was SIS lost the contract with the racecourses to provide this data. And it didn't want to stop providing the data to a couple of its associated companies, namely Ladbrokes and Betfred. So it started looking around for other sources of information, and it found 2 other sources of information. The first one was the tote. Now, Claudia will know all about this, but the tote is this what is now a private company. It was previously some government sanctioned thing.
Which means it's on all of the race courses.
It's historically, from the 1920s, it's had a physical presence on all the race courses, and it offers a different sort of betting from bookmakers that you would go to usually. So it's not
confusing. So it has all the information that you need to work out the odds off course, but it doesn't use it because it bets in a different way, which I didn't realise till I read this judgment. It's pool betting. What that means if you're a kid going to the race courses is that it's inside, so the adults bet there, but they pay out in a different way.
Claudia, don't build up your part. It's Emily's go.
So anyway, the defendant, Sports International Services, entered into an agreement with the tote, whereby the tote would provide some of the information that Sports Information Services needed. Sports Information Services got some of the other information it needed from a number of online betting exchanges. Now, the defendant, Sports Information Services, admitted at trial that the use it was making of the information it got from the exchanges was contrary to the exchange terms. So it knew and admitted that it was using that information contrary to the terms of the exchanges. So anyway, it got the information from the tote and the exchanges, put it together and sold it on to Ladbrokes and also to Betfred.
So it's a simple situation. We've got one middleman, middle person, I should say, getting information, selling it on, and the previous person who was in that position, they try and find out a way of doing that to cut out Racing Partnership.
And I think there's actually, I think it's Lord Justice Arnold who notes that the aim of that trying to cut out the Racing Partnership was to give Ladbrokes and Betfred a better bargaining position with the racing.
And they're all linked companies, right?
Yeah, so the tote, Betfred, Ladbrokes, SIS, there's an ownership structure in place, a whole network. They're all connected.
Okay, so how were the claims put? Explain.
So TRP, the Racing Partnership, brought a claim against Sports Information Services for misuse of confidential information. It said, the Racing Partnership said, we have got the rights, exclusive rights to that information from the race courses. You shouldn't be able to use that information. And secondly, it brought a claim in unlawful means conspiracy. It said the tote, SIS, Ladbrokes, Betfred had all conspired together to cause it loss by unlawful means. And at first instance, in Mr. Justice Zaccaroli, he dismissed the unlawful means conspiracy claim, but allowed the misuse of confidential information claim.
Now, Claudia, it's your big moment. Tell us all what happened on the confidential information part of the case.
Right. So, as Emily said, SAS used to get a whole heap of information from the racecourses, and it would use that to know how to fix odds and can sell that to its partners. When it lost that contract, it got it from another source. And the Court of Appeal said, okay, fine, but if your claim is misuse of confidential information, you have to identify which information is confidential. So you, the Racing Partnership, TRP, have paid enormous sums for all of this information. What of the information that SAS has are you complaining about? And so it got some information from the exchanges, as Emily said. What it got from the exchanges were odds. What it got from the tote was information, a bunch of information about the race date, basically stuff that you'd know if you were on the race course. But Lewison said, you have to look at the pleadings, and Arnold agreed, like, what are you complaining about? The actual information that was said to be confidential was which horses had pulled out of the race, what time the race started, which horses finished, and who won.
Okay, this is not sounding like very sexy information to me, Claudia.
Exactly, right? And that was the majority's point. Yes, it is right to say that when all of the information that TRP buys from the racecourse is packaged up in a particular way, it's very valuable. But this particular information that they're suing about is stuff actually anyone with a telly can get. Because if you turn on the telly, these races were all broadcast live. And so Lewison said, if your actual complaint, look at the pleadings, and we've all been in court with a sort of judge pulling down his glasses, this information, I've got a telly, I could get it. How could you possibly say it's information, it confidential? They then said, well, possibly you can compile publicly available information in a way that makes it valuable and commercially useful. And the tote had compiled a bunch of information in a way that made it valuable and commercially useful.
Okay, so let me understand. Let's imagine that I typed up a document where I just cut and pasted the case analysis summaries on Westlaw about 4 cases. Yeah. That wouldn't be confidential because that's just a cut and paste job. But if I did some link between them, or if I put them in an order of importance or something, that might then make that confidential.
Or if you did a list of all the cases about confidential information in the last 10 years, that would be confidential.
Yeah, it might be confidential.
Right, but here, the TRP was complaining because they are saying these pieces of information are confidential to us. The tote was making the list, right? And the tote said, we are making this list of this information that anyone with a telly can have, and we are selling it to you, Sports Information Services. The question, because there wasn't a contract between Sports Information Services and TRP, so there was no contractual breach of confidence claim, whether they could be liable for misuse of confidential information depended on whether they effectively should have known that this information was confidential to TRP. And Tote, who had put the information together, said, we're entitled to give you this information. And there was this contractual warranty, which was very important for the majority, that said, we have the right to give you this information. By using this information that we have packaged, you will not be in breach of any third party's rights.
So Lord Justice Arnold, he disagreed, didn't he, with the majority, even though the tote had warranted that the information was theirs. Why did he disagree with it then?
It's quite complicated. And that's why the majority disagreed with him. He said that SIS should have known that the tote didn't have permission to get this information. Although there was no contractual restriction on them getting the information, they were a trespasser for certain purposes, which meant that they were in breach of an equitable duty of confidence. And you should have known. But I think
on this
sniff test. But
On the confidential information side, the difference between the majority and the minority was a difference on fact, right? They disagreed as to whether knowledge existed. For the tort to do with confidential information, they all agreed you need knowledge. They just disagreed about whether knowledge was made out. Is that right? Or have I got that wrong?
I think that's right.
He said you should have known that the tote wasn't entitled to package this information and sell it to you.
Okay, so that's a factual issue and that whatever, but the issue of unlawful means conspiracy, it infected, didn't it, the unlawful means conspiracy point?
Yes, because for the unlawful means, one of the unlawful means was that there'd been a breach of confidence. So the question of what you knew about the breach of confidence might be relevant to the unlawful means conspiracy. But let me just break this down, because we have found this really difficult, haven't we? So the conspiracy by unlawful means, what you need is the combination between two or more people taking actions that are unlawful. And by the way, unlawful here, we don't just mean fraud, breach of statutes. It's been clear law for this tort that a breach of contract or a tort is unlawful, okay?
But only one of them needs to be doing something unlawful, right? Sorry, the primary unlawful. The conspiracy is then a separate wrong.
Absolutely right. Only one person needs to be doing unlawful, but you've conspired together, which is one of the naughty things you've done, with the intention of harming Paul, to go back to earlier. So you've got this conspiracy, even though only one person might be doing the unlawful thing, and your unlawful thing has to be the instrument that the damage happens. We'll come back to any cause damage to the claim. But the big issue, as I said right at the beginning, is the mens rea, the knowledge. Do you need to know, both of you need to know, one of you, none of you, that what you're doing is unlawful? And on this, like too many things I've discovered from Quadcast, there have been all sorts of inconsistent decisions and all sorts of incuriam decisions. So the judges analysed this at great length in Racing Partnership. Let me just quickly summarise it for you. There have been a whole pile of cases that have gone through what you need to do to prove unlawful means conspiracy. And they just haven't listed knowledge of the unlawful means as one of them. And that includes the great, Lord Sumption and Ablyazov and stuff. But, you might say forgetting to put an element isn't forgetting, and it doesn't, no, I'm not saying it doesn't exist. It just might not have been relevant on the facts of your case. So the judges in that case haven't had to, but anyway, there's that pile that don't mention it. Then, two directly on the point Court of Appeal decisions that conflict. First one goes back to 1938. It was called British Industrial Plastics. And it was about a chap who left his job, went to competitors and gave them or offered them the use of a process for moulding plastics that were used by their previous employers. And so conspiracy of unlawful means breaching their patent or whatever was alleged. The judge found that the new employers were negligent and muddle-headed. I love that phrase. But their stupidity was stupidity, and they didn't actually know that what was going on was unlawful and a breach of patent or whatever it was. And the Court of Appeal said in clear terms, a person can never be liable for conspiracy if he had no knowledge that the design was unlawful. So bang on point for unlawful means conspiracy. Then fast forward 40 or so years ago to Belmont Finance and Williams, another Court of Appeal case, where they don't cite the British Plastics case. And this was a really tough case, right? The defendant, and it was to do, Emily, what statute? Some Companies Act.
It was the Companies Act. It was a breach of the Companies Act of 1948.
So they were worried that what they were doing might be a breach of statute. So they went to counsel and said, is there any chance what we're doing is wrong? And counsel wrote an opinion saying, no, there's no breach at all. Well done. So you think pretty good people, right? Get advice, go. But the Court of Appeal, X years later, decides that counsel got it wrong. There was a breach of this statute. That is an unlawful means. And that the lack of knowledge of the unlawfulness wasn't a defense. You can be guilty for unlawful means conspiracy, even if you have no idea that what you're doing.
They knew, I mean, it was a capital reduction case, so they knew, didn't they, of the transactions they were entering into. They weren't completely unconscious to any relevant facts.
No.
It's just that they didn't understand or get right the finer points of the Companies Act.
And it was strict liability. Does that make a difference? Because I think Lord Justice Arnold said it did make a difference. Didn't make a difference.
It's always going to be strict liability, isn't it? Otherwise, you'd need to prove the knowledge, wouldn't you, for the purpose?
British Plastics case, strict liability.
Yes, they were both strict liability, but that's the point.
But it's
unlawful means, and you're guilty of the unlawful means in the statutory sense because it was a strict liability. But then when you're trying to get them guilty of the tort of conspiracy, yes, the unlawful means is there, but it's a different question, isn't it? Whether for the tort you need to know that what you were doing was wrong.
Right, because the question is whether the conspirator knows as well. And this is where... So Paul's actually put together a case study that I think illustrates it quite nicely. That tells us what the court decided.
Let's just...
You want me to at least tell you what they decided?
Yeah.
The majority, just, because we have read this case, not everyone has, the majority, by 2-1, decided that you do not need to know that what's going on is unlawful. And now you can do the case study, Paul, because...
Well, let's just explain. We'll do the case study. There's just two things. Firstly, we need to explain the split decision, because what you have is Lord Justice Arnold saying it is a breach of confidence. They knew enough for it to be confidential.
And that's the minority on that decision.
Lewison disagreeing with him and saying no, because the tote provided it subject to these warranties, they didn't know enough. So they're split. And on that issue, Lord Justice Phillips goes with Lord Justice Lewison. So the majority on that is to say there's no breach of confidence. When it came to unlawful act conspiracy, we have Lord Justice Arnold saying you do need to know of the unlawfulness. You don't need to know of the unlawfulness, get it right. And Lord Justice Lewison saying you do. But on that, Lord Justice Phillips goes with Lord Justice Arnold. And the point is that if you think about the position from Lord Justice Arnold, there's no internal inconsistency in what he's found, because he's found, number one, they jolly well knew it was a breach of confidence. And number two, so they knew enough. They may not have known the finer points of the law of breach of confidence, but they knew enough, and therefore they're liable in conspiracy. But the odd thing you have is, because of the way that Lord Justice Phillips, who is the decider on the issues but goes in different directions, there's this sort of tension in the middle of his judgment.
I think the audience will now have worked out why we've been scratching our head about this case.
Well, and the thing is, Lord Justice Phillips' judgment is less than a page.
And it's a 65-page judgment. I mean...
Overall.
Yes, it's unbelievable.
Work out why he thought...
One of them in one and one of them in the other.
And Paul, before we do the problem, can we just remind people, both for the quiz and for any questions, of the email address and everything? And who's monitoring the email address now?
I'm just going to quickly check the emails, because...
Okay, Paul, do a reminder, then let's do the slide.
Quadcast@quadrantchambers.com for the answer on the quiz, and also for any comments or questions you've got. Or you can chat along on the YouTube chat function if you're signed in. You're all obviously watching this have subscribed, obviously, to the Quadrant Chambers YouTube channel, so we don't need to plug that anymore. But you will have signed in, and you can send us your chat comments, which will be passed on to us. Right, let's have a look at this case study then and see if we can try and make sense of this. Probably not. Jack Bright has developed a poker playing system that, when deployed in online casino apps, guarantees substantial wins. The system was developed over a 2-year period, as he recorded in a series of notes he's made in his diary. 2 months ago, he showed the diary to his close friend, Adriana Pictor, who has a photographic memory. Now, she's memorized the system and she sold it to an online casino, Sexy Bet, who've used it to improve the profitability of their product. Now, can Jack sue Adriana or Sexy Bet? Right. Who are we going to start with? Emily, what do you think about
that? Oh, that's mean on that one.
Brilliant.
Go, Emily. Go.
So the first question is, can he sue Adriana for misuse of confidential information? I think absolutely yes, he can. He's showing this diary to a friend. I think that the question is, if you were the friend, would you think, oh no, it's fine, I can just use this, I can just go and sell it, it's absolutely fine? Of course not. It's something that's got commercial value. You can't just steal it. He
must have told her, I suppose, something about it as well, mustn't he?
I'm sure he didn't just open his diary and go, look at this.
Yeah. The point is, he's used it to make money, and it's in his diary, which is a personal type thing, right? And he's shown it to her as his friend. So I agree.
Does that not maybe imply that it's not that confidential?
Sorry, that he showed it to her.
Yeah.
They're close friends. I think it's fine.
I find that every time I gossip with you guys, I have to say this is strictly confidential. The circumstances and the subject matter of what I'm telling you mean it's confidential, and you guys
definitely tell Paul that.
Are you saying I shouldn't have sold it all to the Sun on Sunday then?
Okay. All right, we agree with Emily on that.
We all agree about. What about though the unlawful act conspiracy point then? Claudia, go on. You've got weird ideas on all of this.
So Sexy Bet is, for these purposes, in exactly the same position as Sports Information Systems, right? So assuming that they don't know that Adriana has got this in breach of confidence, like she's gone to them and sold it to them as a commercial thing, and they have developed their product in order to make money, which will be at the expense of Jack. Is it Jack, the original developer? Because more people will go to Sexy Bet than will go to Jack, or some of Jack's business will go to...
What if she says to them, this is all my own work?
Right. So she says, this is all my own work, and they have no reason to believe that's untrue. They're therefore in exactly the same position as Sports Information Services.
They can't have,
and according to the Court of Appeal, they can be liable as conspirators. Except
they won't have the intention to cause loss. Because if they don't know that it's somebody else has a claim to it, they can't intend to cause them.
No, that's not necessary. If Adriana comes to him, Sexy Bet, and lies and says, this is mine, I could sell it to you, or I could give it to the other lot. This is the thing. I'm giving it to you, and we can cream the market and destroy them. So you've got the necessary intention.
Exactly. So because it doesn't have to be your predominant, it's not that they're trying to screw Jack out of business.
But they don't know.
They are trying to get a bigger market share, which will be at Jack's expense, and that's enough.
They don't know anything about Jack.
We have to assume. Unlawful means conspiracy. They have to have the intention to injure. So let's assume they know that with this they can cream Jack.
As you know, as a person in the market. So that's enough. They don't even know that it's unlawful.
My question is, what if she says it's all my own work? You're saying
then she's in the same position as Tote, right? Who said nobody else has any right to this information. We're entitled to sell it to you.
Emily?
So what you're saying, Claudia, is that on the basis of Racing Partnership's decision, Sexy Bet would be found liable even if Adriana had said what Paul says. That's what you're...
Yes, because by saying that, Adriana puts herself in the same position as Tote, and the House of Lords the Court of Appeal said that means no breach of confidentiality, but that doesn't matter for conspiracy.
Emily?
I think this example shows that absolutely Sexy Bet, with no knowledge that there's any kind of breach going on, shouldn't be liable. It's just not fair.
Do you think they would be on the basis of the Court of Appeal decision?
Yes, absolutely. I think the Court of Appeal got it wrong.
Who now?
Well, I'm with the girls, honey. I think on the basis of the Court of Appeal, they would be found liable. We all agree. Actually, I think Claudia agrees that's wrong.
I agree it's wrong for a different reason, though. But yeah.
Oh, go on, I'll give you 30 seconds.
I think this just shows that the sort of unlawful means conspiracy has gone too far. So before, quite recently, you would only be liable if you were joint tortfeasors. And knowledge, I guess, puts a cap on it. But if they haven't done anything wrong to their claimant, I don't think they should be liable.
Let me just ask you this, because we're running out of time. Now, look, you have to know something to be a conspirator in an unlawful means conspiracy. You can't do it without any knowledge, because you have to intend loss, and you have to be part of an agreement and a combination. So there must be there's some mental element in both of those things. So what do you need to know then, Claudia? You're the minimalist. I don't agree with you, but what do you need to know?
No, this isn't according to me. This is according to the Court of Appeal.
No, according to your interpretation of the court, because I don't think...
So on my interpretation of the Court of Appeal...
I don't think that they go as far as you say. I agree that the ratio is you don't need to know of the quality of the act. We're all agreed on that. I don't agree that they have made any findings about what you need to know about the primary facts, and they have certainly not made any findings about the extent to which your knowledge of the conspiracy and the causing loss are also important elements.
Right, no, but because the issue on appeal was whether you need to know that what here Adriana is doing is unlawful.
Okay, look, Paul,
you haven't answered my question.
And the Court of Appeal says you don't need to know that.
No, my question isn't what you said. The Court of Appeal said, what do you need to know for an unlawful act conspiracy?
That you're acting with someone else.
By acting, you're trying to... Your actions may indirectly harm the claimant.
But you don't actually need to know they're going to harm the claimant, do you? You need to know that they might cause you to do better. That's enough.
Yeah, exactly. That's
and
all
not mind. I mean, it has to be unlawful means has to be the instrumentality. The House of Lords have said one of its checks and balances is the means have to be the means.
Which is the whole...
I know you're going to disagree with me, but I think that the Court of Appeal have got not much further than simply saying you don't need to know of the actual illegality like Belmont and Williams. There's nothing in that judgment, in my view, that says you don't need to know the primary facts that amount to the illegality.
So where's the finding that they knew the primary facts?
Well, you've got this odd thing that you've got Arnold LJ saying they did know of the quality of the acts.
In the minority?
Well, but in the majority on the key point. That's the thing. So you've got this very odd thing that Phillips is in the middle, and he sort of takes one from one side and one from the other.
Okay, we're getting very boring. Yeah, really.
Okay, look, guys. Right. It's very difficult. We will return to it. It's not... Is it going to the Supreme Court, Emily?
Well, Claudia tells us that the Court of Appeal has turned down permission to appeal. I don't think it should go to the Supreme Court. Our judiciary has shown no ability to get to grips with this. It's just piling more rubbish on top of rubbish, in my view. But right, I suspect I'm wrong about that.
Say what you really think, why don't you? Right, okay.
Wow, how many sips of the whiskey did you have?
Next week is our Christmas special. It's not going to be a Christmas special where we show you cuts of previous episodes. It's going to be a proper Christmas special where we look back on the year, the highlights and lowlights, and we look forward to 2021. Who knows what 2021 holds? So you don't miss next week's episode. And also, I know this won't apply to anybody, but if you don't already subscribe to the Quadrant Chambers YouTube channel, I hear it's a fantastic YouTube channel. So you need to hit that button on subscribe now, sign in or register on your YouTube account and subscribe to us. And you get notification of these and other programs that Quadrant put out. There are loads of them. With that, all I have to do is thank this week my team.
No. We'll announce the winner later because we've got a problem with the email, Paul. But at least tell us the answer to the quiz. We'll get in touch with the winner later.
You may have got the answer. I can't tell you the answer because until I get the answer.
No, I know that some people have got the right answer, but there's a glitch on forwarding it to you. So just announce what the answer is.
Are you sure?
Oh, hang on. No. We're not sure.
No.
Okay.
No. Next week.
We'll announce the winner next week.
Right. You've made me lose my place now. Let me. Okay, right. So that just to say thank you to the Quadcast team, raucous and anarchic as ever. Thank you as well to Joe Sullivan, our long-suffering producer, sitting there probably.
He's not long-suffering. He's only done it once.
Watching Liverpool play football, probably.
And thank you to Ben Jacobs, Fisheye Productions, for doing the live streaming services. Until next week, don't miss it. Good night.